Hey, Mr. Matthews, good to see you.
Good to see you as well. I hope you are doing well today.
Absolutely. It's good to see you know how to get me on the first floor.
That's right, Jeff. Great to see you. Browse.
Look at this one.
Oh, there's knife up there? Oh.
I may have wrote one of the numbers down wrong. I could have.
I was gonna see.
What are we doing on this one?
Your Honor, this is going to be a negotiated plea.
All right. You ready, Candace? 22 SC 184633, Glenford Lloyd Oldacre. Am I pronouncing that right, sir?
Yes, ma'am.
All right. And Mr. Matthews.
Yes.
All right. What are we doing today?
We're taking a plea, Judge.
Mm-hmm.
Is it negotiating?
It
Is
is negotiable.
It's negotiating? Okay.
I can tell the court the terms now or during the plea colloquy.
Yeah, either one, whichever is easiest for you.
So the defendant's going to be pleading to count one, driving and fleeing and attempting to elude. The state's recommendation is going to be 10 years to serve one, the 1 year commuted to the 10 months that he's already served. And the defendant has agreed to waive any appellate issues with respect to any sentence modifications or appellate rights with respect to the sentence. Counts 2 and 3 will be dismissed. Count 4, speeding, state's recommendation will be 12 months to serve, commuted to time served. Counts 5 and 6 will be null prost. Count 7, driving while license suspended. The state's recommendation is 12 months to serve, commuted to the time served. Both counts 4 and 7 to run concurrent to count 1, and count 8 will be null prost.
And Your Honor, he's not a convicted felon, so he is eligible for behavioral incentive date, but he's not first offender eligible.
Okay.
And I have the indictment signed by all parties here,
All right.
tendered to the court.
And that's your understanding too, Mr. Oldacre?
Yes. Yes, ma'am.
Okay. No, you're good.
Sir, can you raise your right hand? You swear or affirm that the sentence that you provide the court today will be the truth, the whole truth, and nothing but the truth?
Correct.
And lower your right hand. Please tell me your true, correct, and legal name.
Glenford Lloyd Oldacre Jr.
I'm gonna ask you if you speak up. Is that for the record?
Glenford Lloyd Oldacre Jr.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
How old are you and how far have you gone in school?
35. Graduated.
From high school?
Yes.
Do you have any college education?
No, but I did go to barber school and I have my master barber license.
Are you able to read, write, and understand the English language?
Correct.
You understand that you are charged with the offenses that I indicated to the court, and that in exchange for your plea of guilty, the state's recommendation was going to be 10 years to serve one, the 1 year commuted to the 10 months that you've served in custody, balance on probation with a behavioral incentive date after successfully completing the first 3 years of probation.
Correct.
You understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Correct.
Have you had enough time to speak with your attorney about all the facts and circumstances regarding any potential defenses that you might have should this case go to trial?
Yes.
Are you satisfied with your attorney's services?
Yes.
Counsel, do you waive formal reading of the indictment and any defects therein?
I do.
Do you understand that this is a negotiated plea of guilty and that this plea of guilty may be permanently reflected in your criminal history?
Correct.
You understand that this plea may be used to enhance sentencing and other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts.
Yes.
You understand that if you're currently on probation, your probation may be revoked based on your entering a guilty plea today.
Yes.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes.
You understand that you are not allowed to possess or use a firearm while on probation.
Yes.
You understand that if you're not a U.S. citizen, a guilty plea conviction will affect your immigration status regardless of any advice by your attorney or anyone else.
1 second.
Yes.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 5 years in prison.
Yes.
You understand that you waive any and all defenses by entering a plea of guilty today.
Yes.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything for you to enter a guilty plea today?
No.
Your decision to waive these rights and enter a guilty plea because you are in fact guilty of the charges.
Correct.
How do you plead to the charges in this indictment? Guilty or not guilty?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Correct.
You understand that you have only a limited right to appeal this guilty plea conviction.
Correct.
You understand that you have only 4 years from today for a felony charge and 12 months today from a misdemeanor charge, for a misdemeanor charge to file what is called a habeas corpus petition challenging this guilty plea.
Correct.
Your Honor, if this case were to go to trial, the state would expect the evidence to show that on December 2nd, 2021, approximately 10 a.m., while Georgia State Patrol Trooper was patrolling the area of I-20 East near Bill Kennedy Parkway within the jurisdiction of Fulton County, the defendant was operating a motor vehicle in excess of 20 miles per hour over the speed limit. And while the trooper attempted to initiate a traffic stop, the defendant continued to drive at a high rate of speed, failing to yield as a result of a lawful traffic stop. And a pursuit ensued, at which point in time the defendant continued to exceed speeds over 20 miles over the posted speed limit, at which point in time the Georgia State Patrol officer ceased pursuit of the vehicle and put out an APB on the defendant's vehicle, at which point in time, an hour after the initial pursuit, the defendant was subsequently pulled over and apprehended. And as a result of a check on the defendant's driver's history, they've found that he was operating the motor vehicle with a suspended license. State's recommendation is 10 years to serve 1, commuted to time that he has served in custody with the balance on probation. State's respectfully asking the court to adopt the recommendation.
All right.
And Your Honor, for the record, the evidence suggested that Mr. Oldacre was stopped by the same officer who initially engaged him and put out the APB, put out the license plate, reader information, and unfortunately, Mr. Oldacre was back in the same area where the initial pursuit began by the same officer. Mr. Oldacre is 35 years of age. He, as he stated on the record, is a master barber. He does cut hair professionally on a daily basis. He did serve a significant amount of time on this case, Your Honor. He has not had any issues with appearing in court during the pendency of this case. His significant other is present in court with him. We're asking the court to follow this recommendation. He is eligible for a behavioral incentive date. We're asking the court to provide that to him by statute, and we're asking the court to follow this recommendation respectfully.
Anything from you, Mr. Oldacre?
No, ma'am.
Are you responsible for this gentleman's haircut back here at the table?
No, ma'am.
What would you do with that? I mean, just leave it as it is? All right. All right, thank you, Mr. Oldacre. I find this pleas freely, voluntarily, and knowingly given by you, and I'll accept the recommendations.
Thank you.
Thank you, ma'am.
All right, thank you.
Yes. Yes.
Who else? Who is this at Macon State? Do we need to take that one next?
We can, if you, it was a home. Okay, this one, I look, okay. If you want to take care of the people online real quick, we can.
All right, who's-
And I need to take care of Ms. Maureen.
Judge, it's good to see you. Thank you.
You too.
Thank you.
All right, okay, take care.
Who-
Let me make sure.
And we have their
Who's online? Let's see.
Macon State.
Mr. Richardson, you just got here. I gotta take care of my people at Macon State and, the special management unit. I got Ms. Elworth and Ms. Lawrence Shubo here. I don't, Judge, this is on the post-conviction calendar, and it's Adrian Lamar. Ms. Elworth, that's your case, right? That's position one on the post-conviction calendar.
I have Mr. Lamar.
Oh, okay. Does he need to be unmuted?
No, he doesn't.
Oh, okay. All right, so position,
And Mr. Armstrong is here for that position.
position one. All right, so it's 04 SC.
The attorneys, just Mr. Armstrong, that are appearing from the Zoom, or is there another?
Miss Elworth, Katie Elworth. Catherine is out, shows me calendar.
All right, let's see, it's 04 SC 24129 Adrian Lamar. And we're here for post-conviction scheduling conference.
Yes, Judge.
Okay, what do we have?
I'll go because I know the state's ready. They've been ready
Okay.
for 10 years. I have the entire transcript. I've looked through it. I need to file my amended motion. What I had suggested earlier is sending over a go-by to Mr. Armstrong of a scheduling order, a consent proposed scheduling order we could send to Judge Schwall, just giving, I mean, to be totally honest, giving me a deadline that I gotta file it because I have a bunch of stuff set for trial and I kind of need the pressure to just get it filed. And I know the state has already filed a anticipatory response. And so I presume if I raise anything that any of the other co-defendants didn't raise, he would need some time to respond to that. And then we could schedule a hearing and we could have all of those deadlines in the order. That's my suggestion.
Is that your client at Macon State?
I can't. No, I think my client's at special management unit.
All right, Mr. Lamar, you raise your hand for me?
That's
All right, that is, he's at
Oh,
Macon
that's
State.
him. Okay. it's
Okay, I just want to make sure he is on screen and you can hear, right, Mr. Lamar? Raise your hand. Okay, yeah, he shook his head in the affirmative. He can hear. All right, Mr. Armstrong?
The state is perfectly happy with that suggestion. We will not need long to respond unless there is claims that I've not anticipated coming up. Because of the age of this case, back when a prior attorney had the case, I went ahead and filed a response based on all of the issues that I saw as ones that a defendant might raise, as well as anything that the co-defendants had raised and been resolved on appeal. And so this is a unique case where I will not need much time following the defense's filing unless they file something very unexpected, in which case I could ask for more time, but I won't need that time to be scheduled in because, as mentioned in my response, I want it to move as quickly as possible once we get the amended motion out because of the length of time that has already happened, which mostly happened without Ms. Elworth's involvement. And so I just want to mention that as many times as I can.
Thank you.
Because the person who I was upset with is not on the case. But yes, what she suggested with the go by with the scheduling order, I completely agree with.
So when can we expect that by?
I will submit that to the court this morning.
Well, I mean, I kind of want some input on the dates. So why don't
Oh, I was
Mr.
going to do a blank one. I'm sorry. I
Oh,
didn't.
no, why don't you and I do some dates and maybe we could get it to the court by the end of the day tomorrow?
Absolutely.
Let's do that. Thanks.
Good, Ms.
We can have it done by the end of March. Katie, you think you can have that amended motion ready by the end of March?
So I have a scheduling conference on a rape trial and a murder trial next week, so it depends what those judges do to me, but if they don't do anything horrible, yeah, that seems fine.
And then the state 30 days after that. And then we'll be ready to at least bring him over for the actual hearing by May or June.
That's
I
fine.
will actually hurt myself and say 10 days for the state.
We'll give you 30 just in case.
Okay.
And you could be ambitious.
So March 31st is the deadline for Ms. Elward. April 30th for the state. And we'll have the motion in May.
Thank you.
That seems
Alright.
reasonable.
Yeah, Ms. Elward, if something happens, just reach out, okay?
I'll do that. Thank
So
you.
y'all can just send me that proposed order, we'll get it filed.
I will submit that proposed order with those dates and a hearing in
I-
May not mentioned.
Appreciate that.
We can have the hearing May, maybe like, gonna do it May 1st or 2nd?
That will give her less than 24 hours to have my.
That's right, let's do it, May,
Thanks.
19th, or I can push you to June, let's do June the 5th.
That's fine.
I will create that order.
Thank you.
All right, thank you, guys. Have a good holiday.
Judge, I'll take care. Bye.
Yeah.
The next one is Christian Eppinger,
And Ms. Chabot, right?
yes.
So it's,
10 seconds, just close on file.
okay,
What position?
number 2.
To the last one.
Is Mr. Eppinger,
He is. Well, he just,
He is,
Wait,
his
where'd it go?
camera's not on, but he's in the special management unit, it was on.
was on.
And that is Mr. Eppinger. I recognize him.
I don't see another, oh,
And the camera was on and now they've turned it off.
I need to get one on.
I see that, the blank
Hold
space
on.
now, okay.
Yeah, hold on, let's see if he,
Ms. Willis, can you assist us with that?
Alrighty on it, Miss Woods.
thank you.
You're welcome, Your Honor.
And then our next plea will be, Ms. Madden. And that is position 1 on the final plea calendar. Fred Elliott, after we deal with this.
All right.
You want us to go to something else?
Yeah, you want to, because now it doesn't have sound either. Do you want to do?
No.
cr-
Ms. Madden,
Yes.
let's, Mr. Elliott,
Okay.
So, Ms. Chabot,
we'll come back to you.
Yeah.
Ms. Lauren.
because now it doesn't have audio.
Oh, wait, it's connecting to audio. Hang on.
Yeah, if she could just get the camera turned on.
This isn't going to take too long, so I'd really hope that we can.
Officer Brown, where is she?
Yeah, I'm talking to the last.
I need her inside. I need her inside for this one.
You can ask.
Officer Brown, I need you in here for this. Thank you. This is position 2 on that, Christian Eppinger.
All right, well, he still doesn't have,
Wait.
yeah, it's going in and out, audio and video. So,
Hold on.
because audio,
Lauren was trying to wait it out.
yeah,
Yeah, I was trying to wait it out if possible.
Let's go. Whatever you want to do, Judge.
well, I mean, now he doesn't have audio or video.
Okay, that's fine. Like Zoom.
It keeps kind of like going in and out. So this one won't take long though, right?
It shouldn't, Judge.
We'll take this and maybe if it like disconnects and then reconnects, maybe it'll fix it.
No, it's not gonna take long. We can.
All right. So this one is Craig Elliott, right?
Yes.
All right,
Yes,
Craig
Judge.
Elliott, 23 SC 185724. And Miss Madden.
Yes, Your Honor. Good
All right.
afternoon. How are you?
Doing well. What are we doing here?
It's,
I negotiated.
Okay.
And for the record, the state is no price for counts 1, 2, 3, 5, and 6. Moving forward, count 4, which is a felony, battery, family violence, but we're reducing it to the misdemeanor, the lesser included. Mr. Elliott, can you please raise your right hand? Do you swear or affirm the testimony that you're giving the matter currently before this court should be the truth, the whole truth, and nothing but the truth? You may lower your hand.
Speaking to the mic so they
Oh, I'm
can.
sorry. Yes, ma'am.
Please state your true, correct, and legal name.
Craig Vernon Elliott.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone to school?
48, high school.
Did you get a high school diploma?
No. GED.
You have a GED. Are you able to read, write, and understand the English language?
Yes, ma'am.
You understand that you've been charged with battery, family violence, felony being reduced by the state to battery, family violence, misdemeanor.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty and remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Ms. Madden, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes, we've gone over the charging documents, so waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes.
Mr. Elliott, have you been arrested on these charges?
Yes.
I ask because the state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
No.
Has your attorney advised you of the minimum and maximum sentence of the charge that you're pleading to?
Yes, ma'am.
For battery, family violence, misdemeanor is minimum is 1 day to serve, maximum is 12 days, 12 months to serve. You understand?
Yes, ma'am.
You understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 11 months probation, special condition that you have no violent contact with Ryan Thomas.
Yes.
The court does not accept that recommendation. The court can sentence you to the maximum on the charge, which is the 12 months to serve. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded in your criminal history?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand? Do you understand that you waive any and all defects in the indictment, including any mental health defenses by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
In indictment number 23 SC 185724, how do you plead to the charge of battery, family violence, misdemeanor?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the constitutionality of this guilty plea?
Yes, ma'am.
Thank you.
You're welcome.
Miss Madden?
Your Honor, just, I didn't know if the state needed to get
Okay.
there.
Your Honor, had this case proceed to trial, the state would approve beyond a reasonable doubt that on July the 9th, 2020, at 605 Spencer Street, that's Atlanta, Georgia, Fulton County, Ms. Ryan Thomas, which is the wife of the defendant, called police, said that there was a disagreement between her and her husband, about, the mother of his other children. They all stay in the same home. His wife, Ms. Thomas, confronted him about, infidelity, at which point the disagreement became physical on the defendant's side. He started to punch the victim in the face. He kicked her at one point. He pulled her hair, she has dreadlocks. She pulled out a couple of her dreadlocks. This was in front of a child.
There was no harm to the child. The child was not injured at all or involved in it. The child was just present in the home when this incident occurred. I have spoken with Ms. Thomas several times. They are still together and still wish to be in a relationship. There has been no incident since this incident has happened. Mr. Elliott did complete the family violence intervention program already. That's why that's not a condition of his probation. That is already set.
Yes, Your Honor, just very briefly, as the state indicated, my client did complete FVIP already in this case. This incident happened well over 4 years ago. There have been no instances of violence since then. Probably wasn't the best idea for the mother of his other children to be living in the home. She's no longer there. They have since had marriage counseling, and he is a citizen of Jamaica. He has a green card here. That's why we've done the misdemeanor plea for 11 months if the court was just curious. But he is the primary breadwinner for the family. We want him to be able to stay in the country and continue to support his family.
All right. So, Mr. Elliott, do you have boys or girls?
Boys and girls.
Okay. So I don't know which ones were there, but I keep this in mind. Those boys are watching you to learn how to act as a man when they grow up. And those girls are watching you to learn how to be treated by a man.
I agree.
So if those girls saw you hit their mother or another woman, they're going to think it's okay to let a man hit them. You don't want anybody to hit your girls, right?
No.
Okay. So think about
changed.
Yeah, so think about that, okay?
I repented already.
But anyway, just think about that. Repent, whatever, but think about that. Kids watch you to know how, to behave. So we got to teach kids to be better than we are.
Okay.
All right?
I agree. Thank
So
you.
I'll find this given freely, voluntarily, willfully, and knowingly. I'll accept the plea, that misdemeanor. And you also put no drugs, no alcohol, no weapons while on. Okay. Thank
Yes,
you.
Judge.
All
Thank
right.
you so much.
Have a good holiday.
You just need to put your address in.
Yes, ma'am. So now we've lost,
Real quick, I just wanted to ask because the issue of immigration came up. What was the sentence for the misdemeanor?
11 months.
11 months.
Ah, there we go. I didn't hear
Yeah.
that. I just want to make sure y'all didn't say 12.
Right. Yeah, 11 months. Ms.
Thank
Chabot,
you.
we just lost Mr. Eppinger. I'm sure they're probably trying to get him to log back on.
Yeah, I believe, is Miss Willis still on that, trying to get him back?
I'm sure she is.
Yes, I am. I'm sorry. I apologize. I told them to log off and log back in. They said they were having audio issues with the internet too. So
Yeah.
All right, well, I'll wait.
Just hang out. As soon as they get on here, we'll check. What do we got? Oh, okay, wait a minute. Here it is. Oh, hold on. No audio yet. Now it's audio. Now if they turn the video on. Look at it. All right. So we got him here.
Is he there?
Yeah, you're right. Mr. Eppinger, can you hear us? Wave your hand. There you go. All right. So I may interrupt you guys if he pops off. Okay. So I don't know if you've got it on gallery view or whatever. So this is 16 SC 143618 Christian Eppinger. And we've got Ms. Chabot for Mr. Eppinger and Mr. Armstrong for the state.
Yes,
Yes,
Your
Your Honor. So from the state, basically the posture of this case is that Mr. Eppinger pleaded guilty years ago to a case that involved robbery, aggravated assault, and other offenses. He entered a first offender plea. Subsequent to that, he was being arrested for serious charges, at which point he shot at officers. And Judge Schwall found that he had attempted to kill them and that he revoked all of the time that he could on the first offender sentence after revoking his first offender probation and resentencing him. Both sides were wrong as to what the maximum sentence would be. The defense suggested too low, the state suggested too high. The Court of Appeals has corrected that. Essentially, the sentence should be 45 years imprisonment with 20 years to serve on counts 1 for robbery and 20 years to serve for count 3 on aggravated assault and 5 years to serve for possession of a firearm under count 4. The other charges for which he had been sentenced as part of his probation revocation, he had already completed the sentence for under his first offender probation. So those counts were not something that the court was available to sentence him to. And so basically those counts that are below count 4 should be marked as discharged rather than as sentenced, because he successfully completed first offender before his probation was revoked.
From fleeing, attempting to elude down, right?
Correct.
Okay.
So other than the things that I've already mentioned, the only one other than that is the hijacking was null prost. And so that's what the sentencing sheet needs to be altered to in order to comply with what the Court of Appeals has directed this court following the defendant's appeal.
All right, go ahead. I'm sure Ms. Woods has some clarifying questions.
So, Mr. Armstrong, where you talked about it being, the charges being discharged after count 4, do I put the original sentence in there and are we not pro-tunking this or?
So
What do I do?
Ms. Schumer might have a better answer for that, but this is a case where he was under a first offender probation sentence, but those have been discharged. But if you want to have it on the same sentencing sheet as the ones he's getting prison time for, then the sentencing sheet today should read previously discharged by completion of probation or something along those matters. Because it's an unusual case to have somebody revoked, which is why the parties had arguments about what the appropriate maximum sentence was. But basically, for the sentencing sheet to be complete as to all of the charges, it should indicate that 5 through 11 were discharged by operation of law.
Yes, Ms. Woods, we can't
So
have it. Go ahead.
Do you
I'm
want her
sorry.
to do 2 different sentencing sheets?
That's not gonna work because
Yeah.
they're gonna kick it back.
Yeah.
The sentence can't say 5 years or anything like that because the sentence has been served and he no longer has those charges because they've already been discharged. So he's not convicted of any of those charges anymore.
So on 5 through 11, you put discharged by operation of law, right?
Yes.
Yes.
How did he get discharged?
Because they were misdemeanors.
So let me explain this. The defendant had sentences on 10 of these 11 charges. At the point in time that his probation was revoked, the state could still go forward with the 3 more serious ones because the time had not passed for that. But his sentences for 5 through 11 had already passed. And because they'd already passed by operation of law, since it was a first offender sentence for those counts, that those convictions were discharged by operation of law. So a lot of them were misdemeanors, and so those passed within the first year. The more serious charges had not lapsed yet, and so he certainly wouldn't be discharged under first offender for those. So it just happens because of the length of time of the individual counts. They were running concurrently, I believe several of them were, and so just the time period had passed for the state to either revoke his probation or for him to serve his sentence. And since we didn't revoke his probation within those times, those got discharged, but we did revoke his sentence appropriately for 3 of the charges.
Okay.
So once we filled out, why don't we send it back to them and see what they think?
Okay. Okay.
So, but on 5,
I've got to have a number there, so I almost want to do time served, and that would.
No, you can't do time served because he is not convicted of those counts.
So it might be appropriate.
One at a time.
It might be appropriate to say was sentenced to this, but upon completion of that period of time, discharged. But that's a lot for that bracket.
Did you all discharge him, Officer Brown, on those counts?
No, so what he's trying to explain is that for position 5, it was a 1 year to serve sentence. So after that year, he was sentenced, it's pretty much that charge is done. And for 6 through 11, for 6, he got 5 years to serve. And that was concurrent with count 1. Why that would be dismissed, I'm not. I guess he said he served that time already, so that wouldn't be included in the resentencing. And 7, 8, 9, 7 through 11, he was served at 12 months to serve. So that time was already served, so he won't be resentenced on those charges. The only thing he should be resentenced on is position 1, 3, and 4.
I understand all of that. That's great, but they're using the term discharge. when I rewrite this sentence, I have to have something for every count. So,
I would say discharge as of a date in the bracket.
Well, can you put the time and then put discharged?
I'll send it in and send y'all a Word
Discharge as
document.
of 20, not sure what date it would be.
I've never done this before, so.
I
We
get
don't like to
she's-
give y'all normal things.
I get she's got to put the sentence, but I wonder if she puts this, like 5 years, then put discharged.
Yeah, it just has to not be a conviction. He has no convictions on those charges.
That is correct, because the first offender sentence is done and then just magically it goes away at that moment.
So what happens if I put the sentence and not protunct it all the way back to December the 2nd of 2016?
Because he doesn't have those cases anymore. Those are gone. They've disappeared off the face of the universe. Because if you put that his sentence is completed, it will look like when you run his, sentencing, that those cases still exist and those counts still exist, and they'll affect parole and probation and all of those other things. Those counts no longer exist. He has been discharged from those counts.
Okay,
Just
I'll call the sentencing people at the
So-
state and
So
figure out
what
what.
should it say? What should it say?
April just said she's going to call the sentencing
I'm gonna
people.
call the
I
people
mean,
because
the state should know what it should say.
No one knows what it should say because it's literally something that's never happened before. But I believe that discharged by operation of the first offender statute upon completion of the sentence is sufficient.
That's what Mr. Armstrong and I agreed to ahead of time, was that it should say, fleeing and attempting to elude, the disposition being completed first offender, the sentence none, and it discharged by operation of law.
I get it. We're just trying to figure out what to put there. So
I'll figure it out because Ms. Shubo, I don't understand how somebody completes first offender when I don't understand how a charge
because he
can show first. I don't get that, but that's fine. I'll call sentence computation. I'll call Ms. Yarborough and they'll tell me what can be done.
I mean, if everything is concurrent to count one, I don't see what the
I don't see
major
it.
issue is.
Because extra charges look bad don't exist anymore. They look bad on probation. They look bad for parole. No probation officer should be able to, and I'm not saying anything against the probation officer in this room, I'm not, but should be able to stand up and say he's had a prior conviction for criminal damage to property. He hasn't. That is gone. Had a prior conviction. He was sentenced under first offender. The amount of time that the sentence happened is done. When it ends, if there is not a probation revocation hearing, it goes away. The probation revocation hearing didn't happen until after he had completed those sentences. And because of that, they're gone.
Yes. Think about it this way. If you're wondering how this could happen, each individual count is considered on its own, and you start the clock at the same time it's sentencing. And so when you have 1 year and certain year numbers of felonies, and you go past that point in time, he has completed his probation for that offense specifically. And since he was first offender, those go away. Count one was ultimately a 10-year sentence, although only 4 years were in prison. And so that sentence still existed to allow Judge Schwall to revoke his probation for that count. And so that's why, even though you have things running concurrent, one went away, but one stayed, because one was a longer sentence and was still alive at the time the state sought to revoke his probation.
There's another thing too. In addition to that, the credit for time served also has to be added, because he started in this case when he was a juvenile. And because he was a juvenile, normally it cannot be computed just by the custodian. So the sentence also has to say credit from May 1st, 2016 to May 10th, 2021. And
Ms. Shubo, where did you get May 1st from?
that's when he was arrested and sent to YDC.
Okay, because the date that I was given was May the 11th.
That's
what's on the original sentence.
Okay, if I could have written that down wrong. I am reading what I wrote, so there could be two ones and not one. Whatever was on the original sentence sheet, it has to be the same amount of time. And then it also has to have the time from so the May date, whatever it is, till May 10th, 2021, and then February 7th, 2022 till present. So he gets credit for all of that.
You're asking for credit for all of that?
No, he gets credit by law for all of that.
So the probation revocation sentencing order didn't mention the dates. This is just going with the credit that is listed on the original sentencing sheet. And since he was under probation and or revoked on this case the entire time, everything that would apply under the original sentence all the time from that date forward would apply to his current sentence.
And just for the record, there is no revocation order. We don't complete orders when
No, the revocation sentencing order, the sentencing order that happened after the revocation doesn't mention the credit for time served.
Oh,
All I'm saying is that what's in that original sentencing sheet, which I've just checked, that says May 11th, that is the credit that he should receive for this, because he's been continuously on probation or in prison for this case that entire time.
Yes, I checked as determined by the custodian.
No,
So-
you can't check as determined
Well,
by
I'm
the.
just telling you what happened, Ms. Shubo.
Oh,
when
I'm sorry.
the judge
Yes, thank you.
revoked him and we sentenced him.
So, Ms. Woods, I believe Ms. Shubo is saying that when you have a juvenile offender who's in RYDC, the jailer doesn't have quite the same ability to compute the time as you would have somebody who was an adult in the jail custody the whole time.
Gotcha.
I'm aware of that. We're good. What I'm gonna do is call the clerk's office. I'm gonna call the state and call DOC to find out how they suggest and recommend this sentence is written.
To make sure we cover
To make
everything,
sure
okay?
It's correct.
Yeah.
And you
We're not
also
trying to
know-
be difficult. I hope it doesn't.
We just are.
We just
Just are difficult, right? All right, thank you, guys.
It's a confusing sentence and we have to move on, so.
Your Honor, I would like to say, I'm sure that the state is going to disagree, but I believe since the court sent this back, you could actually resentence him to less time on the other charges. I doubt that you would want to, but I do want to say that these charges are part of the, had been subsumed into the YSL indictment, and we know what happened with YSL. If Your Honor is interested at all in giving less time than the 45 years that this sentence will be, I'm happy to make an argument.
He's on
The
video.
state would oppose.
But I have time for the record. Would you like that on the record, Mr. Rao?
Yes.
Go ahead, Mr. Armstrong.
Yeah, he's on video shooting.
I understand. I
He's
did
on
the
video
bond hearing
shooting-
for that.
He's on video shooting a police officer. Judge Schwall was convinced that he was trying to murder police officers. He was being arrested for a new offense for which there were warrants by a clearly marked police officer and did all of these things. I believe he's been on jail calls since he's been laughing about it. Judge Schwall was hot in the transcript on probation revocation. He wanted to revoke the maximum time, which is why we had this particular issue, because the parties neither party got the maximum time correct. And that's why that happened. And so I would oppose any reduction of the sentence that Judge Schwall wanted to impose, which was the maximum.
Right. Yeah, I'm going to deny anything in reducing it because I remember before when I was doing my bond, my prep for my bond hearing, that he tried to revoke 60 years. So, and then I heard the bond hearing where the police officer was shot. So yeah, I'm not going to reduce his sentence. Thank you though, Ms. Shubo.
Not a problem. Thank you. So
Thank
we're
you,
just
Mr.
taking those 19 years off, not anything additional.
Right.
Thank you.
And that was ordered by the Court of Appeals, not by.
Yes.
All right. Thank you so much.
Thank you.
Have a good one.
All right.
Bye.
Mr. Armstrong.
I don't believe I have anything else left. May I be excused?
Yes, sir. Y'all have a good holiday.
Thank you very much.
I also need to be excused. Thank you so much. Have a wonderful holiday.
You too. All right. What do we got now? Because I know that Miss Sanders is going to be very grumpy if she can't get to where she's got to get.
I didn't know she had somewhere to go.
I just need to eat.
She just needs, yeah,
I've
food.
got, a case with Miss Clark. I think we need to get her out of here. I've got one plea and all my probation should be very quick, Your Honor.
And then I have Mr. Richardson's online. Who's your person for Ms. Clark?
I believe it's Mr. Daniels, position 5 on the probation revocation calendar.
And, Mr. Richardson, I'm gonna give, Ms. Off the Brown your number.
We have a plea on position number 20.
Okay, I gotta get pregnant woman out here, y'all.
Okay.
Micaiah Daniels.
Yes.
My police can wait. I got one out.
Thank you, Mr. Ralph, for your assistance. Three oh four, 44304-9421. He's representing Mr. Brooks on your level.
Miss Sanders.
304.
Did Judge Schwall purchase that for you?
No, Kathy.
Okay.
The second we saw it, Kathy was like,
Right.
I don't want to feel like I'm too. I love it.
All right.
This is position 5 on the probation revocation calendar. 23 SC 188906, Mr. Micah Daniels. The state has agreed to allow Mr. Daniels to receive credit for time served and return to probation. So he'd be released today. They did request that he place his address on record today to make sure he is fully registered yearly.
And he also report to the
To ninth
ninth
floor.
floor with that information.
All right. Get your address.
Yes, ma'am.
Go ahead.
3931 Allenville Drive, Southwest Atlanta, 30301.
Your Honor, this is for position 5. Okay, are we going to include the new charges in this revocation or
Yes, we are also waiving, isn't that what your request was,
to waive notice?
to waive notice of the new charges as well?
Okay. Okay, just
Wasn't it-
just to state the new charges are for possession of cocaine within 6 district.
And that case has been DWAPed already.
Well, in lieu of that, defendant, the state would also ask that he do a drug and alcohol evaluation within 30 days of his release, at state expense.
So that's gonna be a new.
And completing a treatment if recommended.
Does that make sense? Do you have any questions? Because we didn't talk about that. I want to make sure you're good. Okay.
You need a second to speak with her?
Come on.
Are you good?
Yes, ma'am.
All right, so it'll be at the state's expense, okay? Now, I don't know how long it'll take them to process you out. Although you put your address on the record here, it's not complete until you go to the ninth floor, okay? So you should get out by tonight. So I would, come up here in or tomorrow morning. Yeah, that's true, it's late. So sometime tomorrow, make sure you come and go up to the ninth floor, okay?
Yes, ma'am.
All right, thank you, sir.
So,
Oh, well.
I'm nervous, afraid of the time, sir. What is the actual revocation verbiage?
Yeah, how much time was he in?
I have 10 months and 15 days.
So it was 12 months, revoking 12 months, give him, or what were you revoking?
I had only that he was in 30 days. Did you have longer, Miss Brown?
You said only 30, really? Double check, sir.
This is Mr. Daniels,
What date did you
correct?
get here, Mr. Daniels?
November.
Oh, okay. So about 30,
Got here.
Mhm.
okay.
Oh, I heard, yeah, 30 days, my fault.
All right, 30,
Yeah, that was the state's understanding.
okay,
Was 30, ready for time, sir?
yeah.
Yes.
So, sir, it may take you 72 hours, so you come as soon as you can, okay? All right, thank you, sir. Best of luck to you.
With the drug evaluation.
And follow any recommended treatment.
Okay, is it credit or reduced to time, sir? I mean, he's done.
What
30 days.
verbiage do you need so that he's released?
I can't
It's 30
give
days.
credit.
It's 30 days, revoke 30 days.
30 days, reduced
Credit.
time, sir.
Yeah.
Reduced to time, sir.
Yeah. All right,
Y'all have to know it and say it on record. She's not gonna do it if y'all are coming up with it. That's what I think.
what else we got?
I think.
Do
you need-
In a way, let me get you out there.
Do you need me to we need to Okay, Judge Manning, that concludes my business. May I be excused?
Yes, ma'am. Have a good holiday.
All right, you too. Good to see you again.
You too. Which one? Which one are we doing Mr. Norman? Which case is this? What's your name, sir?
Michael Parks.
Parks, okay. Thank you.
Okay, so you got 185. Yes.
Number 5?
Yes,
All right, number 5. So we got 22 SC 181248 Michael Parks.
I know, my God,
You ready, Ms. Woods?
what we doing?
Michael Parks, number 5.
Negotiated,
Yes, it's
Okay.
negotiated plea.
is it first offender,
No, it's not.
is it reduced?
No, it's not.
Okay. It's, they need my head.
I think Ms. Sanders.
Do you understand what I'm saying?
Yeah, I do.
Okay.
No, I do.
And that charge is associated with the same overhead number, but I left it
Right.
along with that.
Yeah,
They won't they won't do it twice.
right,
Because that charge is assigned to that overhead.
right.
Okay. Okay, let me-
I'm sure they'll know. I mean, surely, I know it's happened before, but it's
Yeah.
not here or not with us.
I've never had.
Judge, do you want me to proceed?
Sure, go ahead.
Okay.
I apologize.
No,
Yeah.
you're fine. This is 22 SC 181248. Defendant is charged on count 2 of the indictment with possession of marijuana with the intent to distribute. The state's recommendation is 5 years to be suspended with respect to this case. All parties have signed the indictment and I'll tender it to the court.
All right.
And Mr. Parks is requesting a nolo plea and we'll put it on the record.
Okay. Any objection?
I'll
Okay.
defer to the court's discretion.
Okay.
All right, raise your hand. You swear affirm the statements that you provide the court today will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can lower your right hand. Please tell me your true, correct, and legal name.
Michael D. Anthony Parks.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
How old are you and how far have you gone to school?
43, and I obtained my GED.
Are you able to read, write, and understand the English language?
Yes, sir.
Understand that you are charged in this indictment with 1 count of possession of marijuana with intent to distribute, which carries a minimum 1 year to a maximum of 10 years in confinement.
Yes, sir.
In exchange for your plea of guilty today, the state's recommendation is to recommend to this court a 5-year sentence. Those 5 years to be suspended upon the entering of the sentence. Do you understand?
Yes, sir.
Do you understand? Or excuse me, I'm sorry. Have you reviewed this charge with your attorney and have they advised you? Or excuse me, I'm sorry, scratch that. Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty, you may receive a jury trial?
Yes.
Understand, I'm sorry. Counsel, do you waive formal reading of the indictment?
Yes,
And do you waive any and all defects therein?
yes, I do.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
I do.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that if you're currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes.
You understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence.
Yes.
You understand that you are not allowed to possess or use a firearm while on probation.
Yes.
You understand that if you are not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation, regardless of any advice by your attorney or anyone else.
Yes.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 5 years in prison.
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty today?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything for you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges in this indictment?
I believe he was trying to enter a plea under NOLO.
Yes, I'll accept the plea under Dolo. You're fine, sir. It was,
Oh,
no, you're fine.
Is this plea freely and voluntarily given with the full knowledge of the charge against you?
yes.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that you have only 4 years from today for a felony charge to file what's called a habeas corpus petition challenging this guilty plea,
Yes.
for this NOLO plea. You may see the indictment real quick. Sorry.
No, that's okay.
Your Honor, if this case were to go to trial on August, or the state would expect the evidence to show that on August 26, 2020, officers observed what appeared to be hand-to-hand narcotics transactions occurring outside of a BP convenience store within the jurisdiction of Fulton County, in the area of Conley and Jonesboro Road. Officers observed both defendants in this case, in particular, the defendant that's before you today, engage in such a hand-to-hand transaction, at which point in time they pulled over the vehicle or approached the vehicle that they both appeared to have been occupying. And at that particular time, they searched the vehicle and observed containers containing marijuana, in this particular case, to include over 62 grams of marijuana, as well as other indicia of evidence to indicate that that quantity of marijuana was being used to distribute to individuals. State respectfully asks the court to adopt the sentence recommendation by the state.
Ms. Hemingway?
Yes, Your Honor. Mr. Parks is from Atlanta. He is employed. This is an incident that did happen back in 2020. We are just asking that Your Honor does accept the negotiated plea, and we are asking that Your Honor does accept it under NOLO.
All right. Anything else from the state?
No, Your Honor.
All right. I'll accept this plea of nolo contendere, freely and voluntarily and knowingly and willfully given. Thank you, sir. Best of luck to you.
Thank you, Your Honor.
All right.
George Mattis, no problem.
I suppose we have that in that. What are you doing with George Mann?
It's a probation revocation.
Oh.
It's position 4 on the.
And then when are we giving y'all a break so that Ms. Candace Sanders doesn't harm anyone? How long do you need, Candace? Is it yeah. Yeah. I don't either. I mean, you gotta go over there though before they, has Kathy already went over there? Oh, yeah. How you doing? Are you George Mattis Jr.?
Morning.
Good morning. All right, this is position 4 on the probation revocation, 22 SC 183-733, George Mathis Jr. Ms. Hemingway?
Yes, Your Honor. It's my understanding that Mr. Mathis has 1 month and 19 days remaining on probation. We are asking that either his probation be reinstated or that it be terminated. Mr. Mathis is 41 years old. He has been in custody since November the 5th of 2024. He does have an address here in Atlanta, 3511 Eisenhower Circle, Atlanta, Georgia, 30354, and he lives there with his girlfriend. And he's currently employed, or he will be able to get a job at Tip Top Chicken Plant once he is released. He does have 3 children, an 18-year-old son, a 16-year-old daughter, and a 7-year-old son. They're in school. He is active in their lives and participating and going to football games and everything that they have going on. We are asking, as I said, that that it either be reinstated or that it be terminated at this point because he only has the 1 month left on probation and he's going to stipulate to the.
Your Honor, probation is asking for the balance to be revoked. The defendant is listed as a repeat offender with the APD on their 24-week list. The defendant, the petition, the warrant alleges a technical violation for failure to report and failure to pay, but the defendant has new charges. The defendant is on probation for purchase, possession, manufacture, distribution, or sale of marijuana. And the defendant was arrested for the exact same charge on 11/4/24. I asked that the defense counsel waive notice for this arrest, so this revocation could be handled all at one time with the new arrest. The failure to report, the defendant was absconded from supervision from 12/30/23 through 11/5/25. I believe it's about 10 months. The defendant has been missing from probation and his whereabouts was unknown until he was arrested. Probation is asking for the balance, Your Honor.
Probation, you did say from 12/30/23 through 11/5/25?
Yeah, 24.
He's got current charges pending now for manufacturer distribution.
And this is
Possession of marijuana.
10 felony conviction.
All right, what else, Ms. Hemingway?
Yes, Your Honor, we're just kind of going based off of what I've previously stated. Mr. Mathis, he is ultimately denying the new charges that he does have, but he is willing to stipulate to them for the purposes of this hearing. It's my understanding that they did find marijuana. They're alleging that they found marijuana on Mr. Mathis. He doesn't have that much longer. We would ask that he does have a sentence where he can be released before the holidays so that he is able to get back to his family and he's able to fight those charges on the outside.
I'm trying to make one thing. What's his history look like? This here had you living in Stonecrest, so you're in Stone Mountain. That's not where you're gonna live. You're gonna live in Atlanta?
Over a year ago.
Oh, okay.
17105.
All right, yeah.
Is the point.
Say that again?
171. It's an old address. 17105 Kensington, KENSINGTON point. Stonecrest, Georgia. 338.
Did you ask for his history, Your Honor?
What's that? I'm sorry.
Did you ask for his history?
Oh, I was looking at other things, what other convictions he has on this, at least from here. What's it gonna take to make you report?
I was just feeling hard times. I got a hernia. I had to lift my kid's mother. This was just regrouping, trying to get myself back together, get my feet planted. It was just kind of hard having, no parent, got no parents. I had to figure it all out, So I promise it won't be no problem. I guarantee, I promise you won't.
So, but now since you've been in jail, you've reunited with your child's mother?
I mean, everything is all right. I mean, it's not that
Back
bad.
here?
Man, no, man.
Must not be that all right. That's where you're gonna live?
No, not with my youngest, no, man. No, man.
So who you gonna live with? Another?
My girlfriend, yes, ma'am. I promise you everything will be, I promise. No problems, I promise. It's not even that long. I got stuff lined up.
Right, this is.
Please.
Defendant has a month and 19 days left. He's on the repeat offense list, probation, doesn't have an interest in the case.
You said you don't have an interest in the case anymore?
10th felony revocation, he did not report. Just didn't call, didn't report.
What you gonna do when you get out though? Let me ask you a question. Hypothetically, you get out and your girlfriend says, get out and you're on hard times. What you gonna do?
Everything is okay. I got a job lined up. Actually, the job once you say if you do not have anywhere to go, they do have stable housing places for you. The very same day that I can get out, if I get out today, Friday morning, I'll be up there. And then I can go for this $21 an hour, weekly job, Marietta, Georgia. On the bus line. I can easily get myself back together. I've been talking to her the entire duration since November. She's ready for me to get home now.
All right, we'll let you continue on probation.
Thank you.
That's it though.
Thank you.
No more. All right.
Thank you, Your Honor.
Thank you.
You're welcome. Ms. Hemingway just used up her favor right there. Boom.
I appreciate it.
Thank you.
When's he got to report to probation? As soon as he, and then you're gonna report all the time.
Yes, ma'am.
All right. Okay, what else?
That's all from me, Your Honor.
Thank you. Thank you, sir. Best of luck to you.
May I be excused?
Yes, ma'am.
Thank you.
Can we have Mr. Oister, position 2?
Who's up there in the gallery?
I have Mr. Ayers is here for a plea. And then I have Mr. Oister, there's somebody here from PAD. I was trying to get her out of here for probation revocation.
So,
And then I'd like to do the plea for Mr. Bailey on the final plea calendar. He's having a difficult time here in the gallery, so I'd like to do that plea. And then I've got about 3 probation revocations.
all right, so hold on. So,
Have a seat, Mr.
Ms. Sanders, why don't you ask Kathy if she's one over there or somehow, so you'll be able to get your food.
I think it's by you, the clerk barcode, that's what she's asking if she can bring. And print out the invite, that's all the information. I'll ask for a quick number.
Yeah, just ask real quick. So, because I don't want you to miss your food. April, did you get food?
No, I brought my food. I didn't participate.
All right. So somebody's calling.
Would you participate in it?
No, I didn't know that.
Congratulations.
Friday the 13th, never know.
No, we don't want it to be that
No.
day.
So you won't be here.
You're not coming.
I don't need to speed anybody to the, yeah.
Wait.
Are you angry?
We can, hold on.
Did you?
Sorry, the court reporter left.
My sister breathes like that every day.
I got
What
you.
do you do? So when will?
If you can, or?
I gotta, I'm still waiting on somebody to come in. I gotta go do
I
this.
didn't have.
This race security guy just came up here. The
Who you have, Mark?
race security guy.
They're in custody, yeah.
I gotta go get this machine, okay.
Is the German
I know, that's what we're arguing, right?
Yeah.
Tom
Burger guy.
Dude.
It's not something that we can know.
Did you file an entry?
They should have.
Oh, you have Jeremy Gordon.
They file.
You have Jeremy Gordon. That's the young kid from South Florida. You didn't file a bond motion.
You already experienced, you got, y'all move first.
Ma'am,
I was saying, I don't know if it's been in time.
I'll try to get here tomorrow.
Oh, no, he's.
Here's this one.
Sorry.
Oh, thank you. Let me call, what's the name of it?
Hopefully not tomorrow. There's no reason to come if you didn't. Did you get a bond? Yeah, we can, I don't know what the rules are. They have it, you know. So we can just. Well, pretty much should.
We can't represent Mr. Gordon.
Yeah.
But I think you.
Oh, good luck, girl.
Yeah.
Who is Quintavious Williams? Is that somebody new?
He had been arraigned a couple of.
Is he in jail?
Is in jail.
Good. I ain't gonna get no more cases. All right. I'm trying to think of what's the person thing the post office I need to call? Oh, gosh. Yeah, I'm not gonna be, yeah, I'm not gonna with that son. Can he get a lesser sentence? I'm like, you out your mind?
I called my client, Mr. Davis, because he wasn't answering because he couldn't hear because of the sound issues. So I sat here and I called him and I was just like, oh, Mr. Davis, you know, you're released. I'll call you after court. I'll explain to you what happened, but you should go ahead and go. Yes. The same one. And so my response was just, thank you.
The party you're trying to reach is not available.
Name, number. That. So right here. So the audience.
Why? This, you know what I'm saying?
Right.
What do you?
I just like.
Yeah, there's only two. Okay, so can you have that for me?
I got some meeting.
Where's he at right now? Well, you know how long Judge himself?
She's just waiting for what's the name to go.
I need to go downstairs. Judge, you know.
Yeah, right here. No, she was back here. She's printed out her ticket thing so they can.
Whoever's up.
All right, what we doing? Which one you got?
The auditor is position number.
So that Pat can get out, then we're gonna do daily errors and we're gonna go straight down the probation revocation.
Which one first?
Just bring them off the revocation.
Position 2.
Position 2 on the probation revocation calendar.
All right.
Okay, position 2 on the probation revocation calendar, Mr. Oister. The probation is requesting 2 months to serve 50 hours community service and return to Hope House if he is accepted. We are stipulating to the violation. Only thing we're asking for, Mr. Oister has been in for 49 days, so we're asking for the 60 days to be commuted to time served. And there is just by way of explanation, Mr. Oister is accused of not finishing the program at Hope House. He went to Grady with food poisoning on August 7th, and I have the medical records. He went back to the program with the records. They then told him they were going to violate him, and he got scared, and that's why he didn't go back after the 10th. But the young woman here from PAD, and sorry, I forgot her name,
All right.
did see him while he was sick. And again, I do have the records as well, so it was just a oversight.
All right, one sec. You got this, Ms. Sanders, 23 SC 191063, Raymond Oister. Okay, ma'am, you want to raise your right hand? You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, Your Honor.
You need to come up here to the microphone, Ms. Sanders, or come up closer. All right, if you state your name, spell it for the record, please, ma'am.
Okay, my name is Drew Umberger. It's spelled Drew. Last name is Umberger, Umberger.
Okay.
Okay, I'm the lead care navigator at Policing Alternatives Diversion. I've been working with Mr. Oister for almost a year now. He had been released to the Hope House, and we had been in communication a lot, been providing like clothes, some food items, and cell phone. I went to take him his cell phone one day, and he could barely get out of bed. When he walked up to me, he looked awful. He was holding his stomach. He said he ate something the day before, and he'd been like really sick. I could see that he was clearly sick. And I believe the Hope House gave him permission to go to Grady.
And then they kept him?
He was released the next day, but when he went back to Hope House, they said they were going to violate him, and he got scared.
Got to violate him because he didn't come home?
But he had the proper documentation to back it up.
All right, what's probation say?
Well, to include, Your Honor, it's not just for felons reports to the Hope House. The defendant also has a host of misdemeanor charges, to include 2 UFI taking misdemeanors, and from, sorry, look at the date, 9/27/24, and there's a list of driving traffic violations for driving without a license, driving without insurance. And the defendant also has a Clayton County hold, and those charges are unknown.
And those are not part of the petition, but if we would waive those and we'd still be asking for the same thing. Mr. Oister is homeless, which is why he was in the Hope House and had the assistance of PAD. Those misdemeanors are related to him, trying to eat and things like that. So
There is a misdemeanor listed on the petition.
Yeah.
The additional ones. We would waive notice on those and just ask again for time served. He was doing well until the incident that sent him to the hospital.
How long have you been at Hope House?
A month, ma'am.
You'd been there a month before you got sick?
Mm.
So you were there in November?
No, ma'am, I was there in July.
August 7th is when he went to Grady.
Oh, okay.
So it's a month.
And then
before
you just
that.
been kind of avoiding everything since, and then got more trouble in September. And when did you get arrested again?
October 25th, Your Honor.
October, so he's been in how many days?
49 days as of today.
I have a month and 8 days.
All right, so tell me what the plan is real quick.
So the plan is hopefully for him to be released, get back in touch with PAD for services, return to Hope House if they will accept him. We're just not sure as of today if they will take him back.
Well, that's the thing. If they don't, then what? I mean, because then he's just.
Then return to probation with the services that PAD is providing.
And you want to revoke 60? Madam Probation Officer?
60 is fine, Your Honor. I also added a different initial special condition for him to complete 50 hours of community service due to the numerous theft charges, Your Honor.
And that was part of it, yes, Your Honor.
All right, so we'll revoke 60 days and 50 hours of community service, okay? All right. And if there's anything I can do, anything I can sign to try to help with Hope House,
That would be extremely
Then reach out and let me know, because I don't want to set you up for any kind of failure, because,
When I leave here, I'm going straight there.
all right, yeah, just let, Ms. Woods know. Anything I can do, don't let Mr. Norman know.
Well, and can we commute it to time served? Because I know they won't take him until his sentence is over.
Probation, well, he doesn't have a place to stay though.
Clayton County Hold.
Oh, yeah, he's got to go to Clayton County. What's the Clayton County hold? Is it
Permission to speak?
allegedly? No.
Hold on. Well, can we still then commute it because they won't send him to Clayton until his sentence is over?
Well, then I don't know how I'm going to help him get in Hope House. Do you know what the hold is for in Clayton?
Yes,
No. Tell Mr.
I'm not
Norman.
aware what the hold is for.
Don't tell him in his ear.
It's for the same charge I just went here for. He got dropped. I caught that by receiving auto. It's gonna get dropped from
Okay. Yeah, so my understanding is that, yeah, it's related to another,
Theft.
sleeping in a car case, right? Yeah.
Okay.
Sleeping in a vehicle case.
I don't know. I almost think you could do more if he's here for a little bit. So, go ahead.
I don't know if this is possible, but is it possible for Fulton to loan him to Clayton and let him take care of that and then come right back?
They do that, Ms. Woods?
Is that a thing? I don't even know if that's a thing.
I don't think so. Order to send them in, but I don't, it's left up to Clayton County whether or not they're gonna be fine.
Yeah. So Clayton County wants to come get him, that's fine.
Sitting here longer than 60 days. Cause I'm assuming you're time service
Yeah.
in 49 days.
Right.
They own them. And I will move hopefully by tomorrow.
Well, yeah, let's just leave it at the 60 days. Then
Okay.
that will give us time to figure it
Yeah,
out.
but let me know and then we'll see, okay? Reach out if there's something we can do.
Okay. And I can get your information? Okay, great.
Thank you.
Thank you.
Best of
Thank
luck
you.
to you, sir.
Okay, so am I putting as per my custodian?
60 days, credit for time served and the 50 hours community service.
I would need a.
And I'll see you soon.
Oh, yeah.
On record.
I'll be up there tomorrow.
Okay.
What's the credit?
Thank you. Thank you. Thank you.
October 25th. So I wrote it down. I couldn't even read my own handwriting.
And I also like to put for the defendant not to operate a motor vehicle without a valid license or insurance charge.
Absolutely. No driving at all, unless you got valid insurance, license, registration, et cetera. All right.
Mr. Bailey, if we doing that.
Oh, I don't.
Bailey, is that on the same calendar?
Come on, Mr. Bailey. No, that's on the bottom of the calendar.
Okay.
It's 8. That's the city calendar.
Ms. Sanders, you got your phone so they can tell you what the, huh?
I said it's okay, we're here, they'll put it on my desktop.
Oh, okay. I mean, that they can get it. I want to know that they can get it. 'Cause if not, we'll take the break so you can go get it. They didn't get it?
I had a receipt.
Oh, okay. All right, so this position 823 SC 189064. I'm sorry, Mrs. Sanders, you ready? Alfred Bailey. All right, Ms. Carter?
Yes, Your Honor. This is going to be a plea?
Okay, negotiated?
Yes.
Okay,
Just pulling it up, Josh.
okay. Are you sick, Mr. Bailey?
No, COPD kind of acting up on me today.
Okay, all right. Yeah. Do you need to sit while she does this?
I'm good.
You sure? Okay. If you need to, just let us know, okay?
My computer's almost dead. Is it okay if I?
Absolutely.
Miss Bailey, I'm just gonna be behind you, but I have some questions for you. Can you hear
No,
me? Oh, can you see me?
No, he can hear. He's fine.
Okay. Can you please raise your right hand? You swear or affirm that the testimony you're gonna give to the court today for this matter is gonna be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Can you say your true and correct legal name for the record?
Alfred Bailey.
All right. Mr. Bailey, are you at this time taking or under the influence of any alcohol, drugs, or other medication?
No, ma'am.
How old are you?
67.
And how far have you gone in school?
7th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that this indictment charges you with possession of cocaine and possession of a firearm by a convicted felon?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you pled not guilty or remain silent and chose not to enter this plea, you could have a jury trial on those charges?
Yes, ma'am.
Have you looked over the waiver of rights form with your attorney?
Yes,
Did you understand everything that was in that form?
yes,
Have you had enough time to speak with your attorney about all the facts and circumstances about your case, as well as any possible defenses you may have?
yes,
Counselor, are you satisfied your client has a full understanding of this proceeding?
Yes.
Bailey, have you reviewed the indictment in the case?
yes,
And is it your name at the top of the indictment?
yes,
And did you indicate how you wanted to plea on the front of the indictment?
guilty,
I'm sorry.
guilty,
Okay. And did you sign under that plea?
yes,
Are you waiving a formal reading of the indictment, counsel?
Yes.
All right. Mr. Bailey, have you been arrested on these charges?
yes,
Judge of the state's unaware of any other outstanding warrants as it pertains to this case.
Okay.
Do you understand that you're entering a guilty plea to the offense of possession of cocaine and that the state is null processing the possession of a firearm by convicted felon count?
yes,
Has your attorney advised you of the minimum maximum sentence for the count you're entering a plea to?
yes,
Do you understand that if this is a negotiated plea of guilty, which means the state's going to make a recommendation to the court for sentencing, but the court is ultimately the one who decides what to sentence you?
yes,
Do you understand that if you're placed on probation, you cannot violate any criminal laws of any governmental unit or any of the conditions of probation without being subject to a revocation?
yes,
Have you talked with your attorney about what the general conditions of probation are?
yes,
And do you understand that this is a guilty plea which is permanently recorded on your criminal history?
yes, ma'am.
Do you understand that this plea may be used if you were to get in trouble again? I'm not saying you will, but if you did, this plea could be used to enhance your punishment in that future case.
Yes,
Okay. And do you understand that if you're on probation or parole right now, entering this plea could cause your probation to be revoked?
yes,
And do you understand if you are not a United States citizen, any plea you enter would cause you to have immigration issues, including and up to deportation?
yes,
Okay. Do you understand that there may be other adverse or unfavorable consequences of this guilty plea, just like there would be if you were convicted after a trial?
yes, I understand.
Okay. Do you understand that by pleading guilty to a felony, you can't use, possess, receive, or transport a firearm without being guilty of an additional felony?
Yes,
Do you understand that you're waiving any and all defenses, including mental health defenses, to enter a guilty plea?
yes,
Do you understand if you went to trial, or if you entering a plea of guilty, you're giving up several rights? I'm just gonna say them one at a time, make sure you understand, okay?
yes,
You're giving up the right to a trial by jury.
yes,
You're giving up the right to remain silent and not incriminate yourself.
yes,
You're giving up the right to confront witnesses against you. You're giving up the right to the assistance of counsel hired by you or appointed counsel if you couldn't afford an attorney.
yes,
You're giving up the right to the presumption of innocence.
yes,
You're giving up the right to testify on your own behalf or present other evidence if you chose to. You're giving up the right to subpoena witnesses and compel the production of evidence. You're giving up the right to have the charges against you proved beyond a reasonable doubt.
yes,
And you're giving up the right to appeal if you were convicted of these charges after a trial.
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
yes,
How do you plead to count one, which is possession of cocaine?
guilty,
All right, in the state, your honor is dismissing count two.
All right.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
freely,
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
yes,
Do you understand that you have 4 years from today because it's a felony charge, to file a habeas corpus petition challenging the voluntariness of this plea.
Yes.
Judge, this incident happened in April of 2021. The Atlanta Police Department was assisting.
We can stipulate to the facts unless you
Okay.
wanna,
Okay.
unless the court needs to hear them.
No, I'm good. Stipulate the facts. Okay.
Okay, and Judge State's recommendation was 2 years suspended. And I think that's all I have as far as the colloquy is concerned.
All right, go ahead.
Judge, we just ask that you accept the plea as negotiated.
All right. All right, Mr. Bailey, you doing okay?
Yes, ma'am.
Okay, all right. Do we need to call anybody to look at you before you leave? Okay, I'll accept this plea as freely, voluntarily, and intelligibly given, okay? Best of luck to you.
All right, thank
Hope you feel better.
you. All right.
Here.
All right, now what do we have?
Position number 20, Ryan Ayers.
Let me know when you're ready, Miss Sanders.
What is this?
20.
Number 20 on the final plea.
Right.
All right, so 24 SC 003263, Ryan William Ayers. All right, Mr. Norman, what do you got? This is negotiated?
This is a negotiated plea, Your Honor. Just for background, Mr. Ayers is in drug court in Cobb County under case number 2392826. He's been there since August. I spoke to his counselor. He's doing very well. He's in, I think they call it the A team or whatever, which is the team that's doing well. So as part of this plea, the offer is 8 years probation with a 3-year behavioral incentive date, and to continue the drug court in Cobb County. We would stipulate to the facts in this case. We would waive any defects in the indictment for the purposes of the plea. And I know prosecutor has to say things, but we would just ask you accept the negotiated plea once it's put on the record.
All right.
Okay. I'm ready, Judge.
Yeah, go
Sorry
ahead.
about that. Is it Mr. Ayers?
Yes, ma'am.
Is that how you pronounce it?
Yes, ma'am.
Okay, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you put your hand down. Can you state your true and correct legal name for the record?
Ryan William Ayers.
Are you at this time taking or under the influence of any alcohol, drugs, or other medication?
No, ma'am.
All right, how old are you?
42.
How far did you go in school?
I got a GED and completed 2 years of college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Okay. Do you understand that you were charged in indictment 24 SC 003263 with burglary in the second degree by taking?
Yes.
Do you understand that you can plead either guilty or not guilty to those charges? And if you pled not guilty or remain silent and chose not to enter a plea, you can have a jury trial on those charges.
Yes.
Did you sign the waiver of rights form?
Yes.
And did you go over that form with your attorney?
Yes.
Do you understand everything that's contained in that?
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you about your case, as well as any potential defenses you might have?
Yes.
Do you need any more time to talk to your attorney?
No.
Counselor, your client, your counsel. Counsel, are you satisfied that your client has a full understanding of the proceedings that we're in?
Yes.
Mr. Ayers, did you review the indictment in this case?
Yes, ma'am.
And is that your name at the top of the indictment?
Yes.
Did you indicate on the front of the indictment how you wanted to plead?
Yes.
And is that your signature?
Yes.
Are you waiving counsel formal reading of the indictment?
So waived.
Mr. Ayers, have you been arrested on these charges?
Yes, ma'am.
Judge of state's unaware of any other outstanding warrants. Do you understand that you're entering a guilty plea to you're entering a guilty plea to burglary in the second degree and theft by taking?
Yes.
Has your attorney talked to you about the minimum and maximum sentence for each of those charges?
Yes.
And do you understand that this is a negotiated plea of guilty, which means the state's gonna make a recommendation to the court for sentencing? But ultimately, the court is the one who decides whether or not to accept that recommendation and ultimately what to sentence you.
Yes, ma'am.
Do you understand if you're placed on probation, which your sentence includes probation, you can't violate any criminal laws of any governmental unit? You also can't violate any special conditions of probation without being subject to revocation.
Yes.
Did you go over the special conditions of probation with your attorney?
We did not specifically go over the
general conditions?
general condition of probation, yes.
Do you understand that this is a guilty plea that's permanently recorded on your criminal history?
Yes.
And you understand that if you were to get in trouble again, I'm not saying you will, but if you did, this plea could be used to enhance or make your punishment worse if you were to get in trouble again.
Yes.
And do you understand if you're on probation or parole right now, entering this plea would cause them to revoke your probation or parole?
Yes.
And you understand if you are not a United States citizen, any guilty plea you enter to any criminal offense would cause you to have immigration issues up to and including deportation.
Yes, ma'am.
Do you understand that there might be other adverse or unfavorable consequences as a result of this guilty plea, just like there would be if you were convicted after a trial?
Yes.
And you understand that by pleading guilty to a felony, you can't use, possess, receive, transport, or be around a firearm without being guilty of another felony?
Yes.
Do you understand that you're waiving any and all defenses, including mental health defenses, to enter a plea of guilty?
Yes.
And you understand if you, by pleading guilty, you're waiving several rights, and I'm just gonna say them one at a time, make sure you understand, okay?
Yes, ma'am.
You're waiving the right to a trial by jury.
Okay. Yes.
Yeah, let's just say yes or no if you're
Got it.
choosing to waive those.
Yes, ma'am.
Okay. You're waiving the right to remain silent and not incriminate yourself.
Yes.
You're waiving the right to confront witnesses against you.
Yes.
You're waiving the right to the assistance of counsel hired by you or to court-appointed counsel if you couldn't afford an attorney.
Yes.
You're waiving the right to the presumption of innocence.
Yes.
You're waiving the right to testify on your own behalf or present other evidence if you chose to.
Yes.
You're waiving the right to subpoena witnesses and compel the production of evidence.
Yes.
You're waiving the right to have the charges against you proved beyond a reasonable doubt.
Yes.
And you're waiving the right to appeal if convicted of those charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to count one of the indictment, the burglary in the second degree?
Guilty.
And how do you plead count two, the theft by taking?
Guilty.
And is that guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you have 30 days in which to appeal your conviction based on your plea?
Yes.
And you understand you have 4 years from today for a felony and 12 months from today for a misdemeanor to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Okay. And Judge, the recommendation is 8 years probation with a 3-year incentive date. He is in Cobb drug treatment court for a different case. And the facts of this case are that this happened in August of 2023.
And we
Did
would
you say you
stipulated
Okay.
to a factual basis.
And we do have restitution, Judge.
Okay.
And the restitution amount is $4,731.85.
Okay.
And that's for
Plumbing?
plumbing fixtures.
Okay.
And you have some of those.
Yeah, do you want me to send them to you?
Yeah.
Ms. Caitlin, was that just on count one only, or is that one of our counts?
Is he pleading
To the indictment,
He is.
it's 8 years probation as to each count?
I would say 8 years as accountant. Yeah, that's fine. Is count? Depends on the language of count two.
Yeah, count two would have to be, I think, 12
Count
months.
two might just have to be 12 months
Yeah.
concurrent. Based on how it's charged, I have to pull up the indictment.
Oh, all right. I think count two has to be 12 months.
Yeah, I would say just make count two 12 months concurrent. And have the sentence be on count one, Ms. Woods. Thank you. Yeah.
All right. Anything else, Mr. Norman?
No, I think I said everything at the beginning, but
Yeah.
I would just ask you to accept the plea.
Was this property owned by your mother?
No, ma'am.
No?
This was a house that was being constructed. And they were using some very high-end fixtures, apparently.
Oh, okay. All right. So you're gonna live in, who's doing the drug court up there in Cobb, is that?
Judge Childs was our
Oh,
judge. Is that what you mean?
Right.
Judge Marbett is taking over in
Oh, okay.
January. We just had our last court with Judge Childs yesterday, as a matter of
Oh,
fact.
okay.
Yeah, and I talked to his counselor, not the judge. So,
All right.
yeah, sorry.
So you're gonna live up in Marietta?
Yes, ma'am.
Okay. All right. So I'll accept this plea freely, voluntarily, and intelligently given. And part of it, if you don't complete drug court, that could be a violation, right?
Yes, ma'am.
So do we have, I guess probation will set up a plan for the repayment of the, okay. Are you working?
Yes, ma'am.
Oh, okay. All right. Anything else?
No, Your Honor.
All right. I'll accept it as freely and voluntarily and intelligently given. Thank you. Best of luck to you, sir.
Thank you.
Thank you. You'll have to talk to
All
that.
right. What else?
Yeah, in regard to position one on the probation revocation calendar. Nope.
Not?
Yes,
I just know that.
two aren't coming out for me and two aren't coming out for him.
What are you on position 3? Okay.
Position one. Mr. Fleetwood, I'm sorry.
Trevante,
That's-
Treviante.
24 SC 002093. We're requesting a reset on this matter, Your Honor. Part of the revocation is due to some charges he picked up that is going to be held before Judge Richardson on the 10th of January. So we're hoping to reset it for after that time to come back for the probation revocation.
All right. State okay with that?
Yes.
All right.
And I have the same announcement for Mr. Quintavious Bailey, positions 11, 12, and 13 in equal order. That's 13 SC 120263, 13 SC 120273, 13 SC 120682. He has picked up new charges, 24 PI 008075. He's requested a reset based on the fact that he's got a preliminary hearing on the 16th. He believes that probable cause will not be found in that matter, and that may help out with the probation revocation. So we're asking that the case be reset for sometime after the 16th.
All right. What date you got, Miss? Okay. All right. So you want his sometime, well, that both looks like gonna be January, right, Miss Woods?
And I told them, you're gonna be sitting here through Christmas,
Right.
really don't harass me is what I was asking for, but.
Cause that'll be part of the reset. Do not harass your attorney. And don't harass Miss Woods.
No, I just told them, I don't know when our next revocation
Right.
calendar is, but I know we have a lot of people that are coming up for revocation.
Right.
So, they're gonna be, last in line or.
Oh, yeah. Yeah.
And then I believe we're gonna start then with position.
So I have a quick,
Jeremy Brooks.
revocation.
I bring out Jeremy.
Are you ready on yours, Mr. Richardson?
I am.
I don't know where Officer Brown is.
No.
Okay. We're ready on position 6. Are you ready? Yeah. Okay.
6, that's
That's
Jeremy Brooks. Okay.
Is on Zoom for that.
What calendar?
The probation revocation now.
Maybe discovering the defendant's. I can't.
You heard it.
Did they text you, Candace, and tell you anything? Hopefully they would tell you if they can't. I mean, as long as they can get it. I don't want you standing in line and they can't get, you know.
Okay, his attorney's on Zoom. You can-
Yeah.
That's you, Anthony?
All right, so this is number 6. You ready, Miss Anders? 14 SC 127216, Jeremy Brooks. And if you look at the screen there in front of you, you can see Mr. Richardson. Do you see him?
Yeah, ma'am.
Okay, all right. What are we doing here, Mr. Richardson?
Judge, I'm asking that this case be continued and I, on probation. And these are my reasons why, Judge. It's kind of, if I was Judge Judy, it'd be kind of the theme of no good deed goes unpunished. Mr. Brooks effectively had an apartment. He got married to Miss Denisha Dawson, now Miss Denisha Dawson Brooks. He had a friend who was coming out of custody. The friend didn't have a place to live. So he let him sublet the apartment from him. Casually, didn't have really writing. While he and Miss Dawson moved into their new home in an attempt to purchase another home, an actual home, not a rental apartment, they got behind on the rent. The friend ended up going back to jail. The girlfriend was staying in the apartment. At some point, the wife, Mrs. Dawson, the wife of Mr. Brooks, said, look, you guys are messing up our credit. You guys got to move. So while he was at work, he told her to go check the apartment. She and her kids went to check the apartment and it seemed abandoned. He said, well, good, change the locks. When she changed the locks, the young lady who was the girlfriend of his friend, who he had loaned the apartment to, showed up. An argument ensued. She told the police, the young lady who was subletting, that the wife of Mr. Brooks didn't have permission to be there. So the officer actually called Mr. Brooks from his job and says, look, we're going to lock your wife up if you don't come and show proof that the apartment belonged to you. He tells the supervisor, can I have 30 minutes? Shouldn't take long. He goes to the apartment. The officer, I think, is actually satisfied with the fact that the apartment was actually his. Tempers flowed. His children were there. His wife was there. A young lady who was not even connected to the apartment, but who doesn't like he or his wife, got behind him, and between he and his 14, 15-year-old kids started to argue. He turned around and said, hey, back up, and kind of pushed her back. They ended up charging him with simple battery. He was called from work to come there to defend the apartment that belonged to him. Because he was under this probation, the officer said, well, you're under probation, I gotta arrest you. So now he's been sitting there for about 2 weeks. He's about to lose his employment. They have 6 children between the two of them. She works for MARTA, he works for a warehouse freezing container unit. And so we'd asked the court to reinstate his probation pending resolution of that misdemeanor case. It is before, I don't believe it's accused yet, but I have been retained for it. But that may be a month, 2 months, 3 months, 6 months. Other than that, I believe he is compliant with probation, Judge. That is all.
Sure.
Okay, so the defendant's booking show a simple battery and also show a battery family violence. Is that the same case or are those 2 different incidents?
That is a separate case. The family violence was with his now wife. I believe that case has been dismissed or in the process of being now passed. She is in the court now or on the platform. It says Denitra Brooks right below Mrs. Wood's picture.
For the purpose of today, I would ask that defense counsel will waive notice for the new charge because it's not
Certainly.
added to the warrant. So that can be handled today as well.
That's fine by me.
Probation is asking for, because there is 2 violent misdemeanor charges within short time span. Revoke 60 days to reinstate the balance upon completion of an anger management course. The the defendant may be placed on unsupervised probation. That's the right.
All right,
Judge-
anything, go ahead.
Judge, I'm not exactly sure what day Mr. Brooks, can you tell us what day you were arrested? I don't have it in front of me, I'm sorry.
November the 12th.
So he's been in jail for 1 month today. I judge, he literally is about to lose a job. They have 6 children. They don't receive any aid. He works
28
for-
days.
Right, so 28 days. We'd ask the court to let that be time served and let him return back to probation. They have, like I said, 6 children. They don't receive any, they're proud of it. They don't receive any aid. She works for Marta in the custodian section. He works for warehouse. She's holding together with kind of glue and spit. They have children from 14 down to, how young is the youngest, Ms. Brooks? 5?
5.
Yes. So that's what we'd ask, Judge.
All right, one second. Let's 240-00891. One is coming up.
Your Honor, I'm not sure if this is appropriate, but is it appropriate to ask for marital counseling while under supervision?
Let me see if
we already
did marriage. We're doing marriage counseling.
Stop, ma'am. Stop.
I believe they are doing marital counseling. I certainly could provide proof of that to the clerk or to the court before the close of business or first thing tomorrow.
If it's appropriate, I would like to add that as a condition to the application.
I'm just reading this real quick. So the next court date is January the 14th in front of Judge Edie for the family violence
Okay.
case. Yeah, Judge Edie, sorry. I said that kind of with a bad Southern accent. I'm sorry. Let's see. All right, hold on. All right, let's see. I was just making sure it didn't say no contact on your bond conditions because I didn't want to, but it says no further violent contact. But you got arrested for the simple battery in April. It was happening in June of 2023, so you didn't get arrested till later.
Right.
And what are you asking for? Me just let him go and put him back on probation?
Let him resume probation if counsel, our probation officer wants him to do family counseling or anger management in the interim. I anticipate, honestly, Judge Edie's case being dismissed based on the information that I have now and Ms. Brooks' posture, but really more of what I have now. And certainly, Judge, I'll tell you, as an officer of the court for like 34 years, I looked at the video of when this new offense occurred. He's standing there talking to an officer, and you can see, because one of the children has a video camera, and it's confusion from people who really shouldn't even be there. They're yelling and screaming and pushing and kind of going crazy. He was literally called off work to come to a location to verify his residence. That was the only reason he was even there, but for that he wouldn't have been there. If they'd gone to the rental office, they would have seen that the lease was in his name and not any of the people, the participants who were there instigating.
All right. So yeah, we'll add go ahead.
I do want to remind the defendant that he is on first offender probation.
Pardon me?
He's on first offender probation.
And I believe that's why the officer arrested him initially there, because he found out he was on probation.
Well, so I'll remind you let's remind you this, Ms. Brooks. So you've had 2 bites at that apple because there's been 2 other offenses allegedly that have happened since your plea. One more, and probably going to send you to prison.
All right, it's not gonna be no more.
Okay. All right. So you want to add counseling? What else?
Marital counseling
Okay. Marital counseling. What else?
and complete a anger management course.
More than just the 1 day. Do you want the FVIP or anger management?
Anger management.
Okay.
I can ask a question.
upon completion of the anger management, he may be placed on unsupervised probation because he is eligible by the, State Bill 174.
Did you want the 1-day anger management class?
I'll leave to the court's discretion.
Did you already take the 1-day class?
It wouldn't matter whatever players. Yes, I take it.
Did you take it? That was part of your bond condition. Oh, no, you
Yes,
didn't.
I did.
Right, yeah, well, let's take something a little bit more than that. So once you complete that anger management class says it's more than 1 day, then she can maybe get you non-reporting, okay? All right, we'll go ahead and let you go, but it'll probably take a couple, 3 days to get out, all right? But you're gonna remain on probation, get into marital counseling, okay? All right, best of luck to you, sir. Anything else?
Thank you, Your Honor. I appreciate it. May I be excused?
What's that? We'll go ahead and give him his credit for his time served and release him back on probation.
Thank you, Your Honor.
He's been in
28 days. I think.
28 days, yeah.
That concludes my business. May I be excused for now?
Yes, yes, good abuse.
Yes, I'm sorry. Yes, sorry. I was trying to read my handwriting, make sure. Yep, 28 days. All right, anything else?
None for me, Judge.
Thank you. Have a good one. That the last case? Or-
No, we've got a couple more, Your Honor.
Yes. Candace, take your phone and call them and see if they were able to.
If I go back there and get my charger, my food's down now, but.
Okay. Which one's, I'm sorry, which one's now?
Smith, position 7 is next.
Okay.
We have position 8, Barry, position 9, position 10. And then Bailey's reset. We have position 14 and position 15.
Okay.
Have a plea with Jacoby on.
Okay.
7. But, Bailey's reset, whatever. Don't you have some resets in there?
Oh, we have 2. That's
Hey, Greg.
They got it?
Yeah.
All right, good. Is it enough for 2? No, I'm just kidding.
Let me just focus on.
Okay.
Your court date would miss.
You're Duran Smith, right?
7.
Yes.
Okay. All right. Duran Smith. Did you need this calendar?
Oh, I don't know what that.
He said after the comment,
Thank you.
try to give him a ball.
Okay.
You ready?
This is position 7, Duran Smith, 16 SC 148056. The recommendation from probation today was that the court revoke 6 months. However, Your Honor, Mr. Smith did want me to ask the court to consider giving him time served for the 28 days that he has been in. Mr. Smith enrolled and completed the Veterans Court, and that was completed July of this year, 2024. Was it
26?
July 26th of 2024? He completed the Veterans Court. In his mind, when he completed Veterans Court, he was under the impression that he was off of probation, which is not the case because he did Veterans Court as part of this case as well as an additional case that he has before Judge Cox. He also has a revocation before Judge Cox. I believe that's supposed to be on the 7th. But we did anyway want to ask the court for time served. The reason for the revocation is that he did pick up new charges in Upson County, and that's for allegedly having a firearm in his vehicle. And speaking with Mr. Smith, he advised me that he had to place his father in a retirement facility or nursing home. Retirement facility, nursing home, sorry. He had to place his father in a nursing home and had to get rid of all of the items in his home. Upon doing that, he didn't realize that a firearm was in one of those boxes when he was making that move for his father.
What branch of the military?
Man,
What branch of the military?
Army. 63 Bravo 10, light wheel vehicle, like mechanic.
You go to airborne school?
I don't like jump out of planes, young.
I didn't like it either, but I did it. It was $100 a month. That was big money. Probation, what do you say?
Leaves the discretion of the court, Your Honor.
That's what they always say, Miss Woods. So, how long does he have left on probation?
I have 1 year, 10 months, and 7 days, which then is eligible for unsupervised probation.
Even veterans want Mr.
I
Peter
did
Franklin.
originally say revoke 6
And
months
them
on the
didn't know
gun charge.
anything.
The violation is, a possession of firearms, value pay, and, upon conviction of 6 months, to be placed on unsupervised probation.
I'm in there. I have no probation.
And not revoke any, give him time served?
I expressed that.
He's been in for a month and 18 days.
Yeah, I think that's good. Month and 18 days, you said? All right. Month and 18 days sound good. Anything else you need him to do?
Time served.
Time served, yeah. Anything else he needs to do? Any other conditions?
No. It's, the court wanting to be placed on unsupervised, I can check that box.
We'd like to do unsupervised, you know, and speaking with Mr. Smith, he keeps telling me that everybody that he was involved with in the Veterans Court was shocked that he was still on probation. He's like, nobody knew that I was still on probation. We all were under the impression that it was terminated.
You didn't take legal advice from those people, did you?
No,
Okay.
ma'am.
So let me say, are you gonna be living in Upson?
He's my,
Huh?
I'm married. I'm married.
That's what I'm saying. Are you gonna be living in Upson County? All right, and have you got,
If I knew,
no, step back. Do you have work and stuff down there?
ma'am,
Do you have work and things down there?
I own my own company.
So, okay.
Yes, ma'am.
So it's gonna be hard if you go to Upson County to Fulton County, report to probation, all that's what I'm trying to get
I
to.
mean, it's no problem. That's what I did during the veterans program. I made that hour and a half trip every day, even just for a 30-second drug test. So that's whatever I need to do, Your Honor. That's no problem. The reason, I honestly, even Miss Nikita Franklin over the veteran program, she knows that there's no paperwork showing that I was on probation.
But, well,
I understand what you're saying, Your Honor.
Yeah.
I do.
Well,
whatever it takes.
we'll fix it. I want to try to help you out. You completed, Judge Glanville's program and you're a veteran, I'm a veteran. We'll help you out, okay?
Yes, ma'am. Thank you.
All right, so yeah, how about that, Madam Probation Officer? Make him let him go to non-reporting so he can get his stuff together and handle whatever in Upson County. All right, best of luck to you, sir.
Thank you, ma'am.
Yeah. So, who's on screen? Is that the one on screen?
That's a plea. We're gonna finish this count.
Oh, yeah, okay, yeah, sorry. Montrez, Berry.
Montrez Berry,
What are you doing with him?
he's coming, we have an agreement. So probation is recommending 30 days revoked. Is this on the, I don't know.
Oh, yeah.
We're waiting for him to come out, but I was just letting everybody know what's gonna happen. I mean, they're recommending 30 days, revoking 30 days. He served 27, so we're asking for credit for that time. He has to complete, was it a family violence or an anger management class? I can't read my handwriting. I just have class.
He's on there. Yeah, family violence.
Okay,
And then he can be non-reporting upon completion of that class.
all right. You good with that?
Yes,
Okay, we'll get him out here. Boy.
I'm having come in and sit on the back.
Okay, that's fine. All right, so we got is it Montrez? Montrez Berry, 22 SC 184198.
Yes.
All right, Mr. Norman, go ahead.
Good afternoon, Your Honor. Mr. Berry is stipulating to the violation alleged in the petition. The recommendation is to revoke 30 days and return him to probation for him to complete the family violence class. We are asking for the court to accept that and give him credit for the 27 days he served and allow him to be non-reporting upon completion of the family violence class.
All right, Madam Probation Officer.
Yes, Your Honor.
All right, so you know the FIP's like 24 weeks long, right?
Sorry, what?
The Family Violence Intervention Program. Sorry, FIP, it's like 20 or 24 weeks long. You understand that, sir?
And
Yes, yes.
state, Your Honor, this is the
Yes.
second chance. The defendants,
No more chances?
he failed to complete the family violence, which is part of the violations. This is the second chance.
So I need you to respond verbally, okay? This is your last chance. Okay? So it's a class, you go there, you learn something, learn how to treat people, learn how to be treated and stuff like that. So it's good for you. It's not a bad thing, all right? All right, that's it. After this, that's it. Then you don't want to go to prison. All right, let's get out there and do that, but that means you're still on probation for a while. All right, thank you.
Yeah, she's gonna talk.
We got DS Monroe, number 9.
Your Honor, this is just going to, the revocation warrant is going to be withdrawn. So he's just coming out to hear those words.
Oh, okay.
You're gonna include all the case numbers on that whenever you dismiss or return.
I'm sorry? Was that for Ms. Brown?
You're gonna include all my special case numbers. If you're doing a dismissal or withdrawing that,
The warrant cancellation, and I'll send it,
you'll put all the pretty numbers on there and you be on there.
oh, it.
Are
it
there
does-
numbers associated with this one?
No, this is just, this is
Okay.
something I just filed.
This guy coming in.
It doesn't require a judge signature. It requires a person.
Yeah, but it doesn't include, this one have a PD number.
Preliminary thing today is. I forgot.
It'll be put on,
They don't, the clerk's office doesn't recognize it. It has to be an order signed by the judge closing those PD numbers out.
well, we took the PV numbers on the warrant cancellation.
They don't close them. That's why I had a little. With them. Y'all's bosses are supposed to be talking to those over there about that. Yeah.
I would
It's
have,
beyond
I would have,
pay grade.
I have to notify.
They know, I have, they were supposed to be in a meeting, but you go, you're doing that. But I.
Ms. King.
Yes, me, Mr. Monroe.
Yeah, I spoke.
You said Monroe, not them.
Oh,
He was-
Oh, Turner's mine. I mean, I can, we can do.
Is Turner right there?
Go ahead.
he's-
Tell, but just let Ms. Madam Court know that y'all
Yeah.
was switching.
Yeah.
That's why I offered to give him a calendar and say,
Turner.
Which one now?
They brought the
Jonathan,
wrong one, we're gonna handle it while it's right here. Mr. Turner, position 14.
Jonathan Turner, position 14.
yeah, Mr. Turner is position
What,
14.
yeah, you ready, Ms. Sanders?
Oh.
Ms. Sanders.
Okay, sorry. Position 14 on the probation revocation calendar. So Mr. Turner, in addition to what's on the petition, we are waiving notice on, he's got some additional charges. So we are waiving notice on those additional charges. Probation is recommending that he serve 4 months and then return him to probation. He has been in for 52 days. We're just asking for credit for that time. And stipulating to the violation.
All right, Madam Probation Officer.
Yeah, Turner, the new, violations are violent in nature. There's about 6 new charges, Your Honor. One being aggravated assault. I am asking to revoke 4 months. And reinstate the balance, and for the defendant to be on active probation for 2 years due to the state bill 174. In conclusion of those 2 years, place unsupervised probation.
All right.
And just as the court's aware, he's also on a no bond status, so on one of the cases. So.
All right, so we'll do that, Madam Probationer. Okay,
You gonna send that?
Now what we-
For the,
I'll send that. Okay, I gotta send that from my office.
okay. Don't forget it, please.
go ahead, Ms. King, you can call your 3 real quick.
Oh,
That's it.
Are y'all done?
Yeah, thank you.
That, did you give what you needed to you?
Revoke 4 months.
Yeah, revoke, yep. exactly.
On the record, case. That was Barry 22 SC 184-198 probation.
I don't know if that one. He leaves, it's all, he doesn't hear it, so I just want to show it.
The case number?
No, that was Turner.
That was Turner.
Oh, that was Turner?
That was Turner.
That was Turner.
That's why I asked it.
Yeah, yeah, that was, but he knew it was Turner.
No, I'm just saying, when you guys, once you.
Oh, yes, Turner, but the number is 18 SC 160028.
To what?
Jonathan Turner.
Jonathan Turner.
That's the very last.
I understand, and that's what you just said was for Turner.
Yes.
Okay, okay.
Ms. King, so, look, Ms. King's gonna take the 3 people that the 2 people that she brought over here. Make sure you read every page, print it off, and keep it with you at all times, all right? Something happens, you don't need to call our office, you don't need to call the DA's office, you need to call the police, all right? Y'all stay healthy and safe. Have a good holiday. And I'm getting to the rest of y'all, okay, for, safe families. All right, who we got now? They bring somebody out?
They're bringing out Thea's Monroe.
Okay.
While we're waiting on that, can I make an announcement on position 10? 'Cause
Sure.
she's not gonna come out.
On the record or on?
On the record, I guess. Yeah, position 10, Kateria Knight, she has an additional unindicted case that she's not waiving notice on, so that has to be added, so it's like a reset to handle it all at once.
All right. Probably be in January too, right?
Maybe.
All right.
They're last on my list.
This is position 9, Theus Monroe, 10 SC 88325. His probation is over. So it's my understanding that probation is going to cancel the warrants that were previously taken out.
Yes, Your Honor, his case expired while he was in custody from the DOP, waiting for him, and I will give the warrant today.
All right. Anything else, Mr. Monroe?
No, Your Honor.
Just let me go home, right? All right, sir. Best of luck to you.
Thank you.
All right. Have a good one.
And in position 15. And his own.
15. Okay. 15. To here.
Yeah.
Abdullah
Abdullah
Ram-
Ramham.
Abdul Rahman.
common spelling, Miss. Because you want to see, it because I know you can't really understand anything.
Position 15, if you have
Yeah,
your
15.
calendar.
I think she gave me her calendar. She was being nice.
Yeah.
Look, she's so nice. All right, and we'll go ahead and spell it too. This is position 16.
15.
Excuse me, 15. It's 16 SC 143978. First name is Tahir, Tahir. Middle name is Tayyyib. Last name Abdulrahman.
And how do you pronounce that for the
It's
record?
Abdul Rahman.
Your Honor, before we begin, this case was sent in front of Tom. I will ask the court to waive the time process in order to complete the revocation today.
Okay.
We'll waive, Your
Okay.
Honor.
All right, we'll wait. All right.
The violations were failure to report the defendant's spent substantial amount of time in custody, leaving the DOC. Probation is willing to reduce the time served to revoke the 23 days the defendant has served in custody.
How many days you say? 600?
23 days.
23, okay.
Prior to his
then
arrival
there-
here in Fulton County, he did over a year.
Oh, okay.
Where he was incarcerated.
All right. So are you okay with that?
Yes, Your Honor.
All right, we'll take care of that then. Thank you, sir.
Thank you.
Best of luck to you. All right, what else?
That is all for us, Your Honor.
We're just waiting for Mr. Hudson to join us online.
Oh, okay.
He should be on in about 4 minutes.
Okay, that's all you're in custody? Okay.
Or safe families person. Come on. All right, so I'm signing these and putting these in place. Y'all keep them with you. That means print it out. Don't keep them on your phone, because if you go to enforce them and you show APD or any other police department your phone, they're gonna say, that's a nice phone you have, and the screen's cracked. You have to print it out and keep it with you. read every single page. There'll be a time on there in a courtroom you need to appear in. On time is late. So if you've got 9:30, I'd be here at 9:15. If you're late, I could dismiss your case, all right? All right. So she's gonna get it to you. You can either hang around or I'd probably go home and you probably get it in email in the morning. Yeah, probably get an email in the morning, okay? Because the clerk's office has to accept it. Ms. King, you better quit. Bring me in folders. All right. There you go. Best of luck to everybody. Okay. Ms. King, are y'all going to the 7th floor? Oh, I thought it was in the 7th. I mean, the thing at the 7th floor.
Oh, it's over.
Oh. That's right.
We took care of all your inmates. Mr. Barlow last time.
Is Jacoby gonna be? Is,
The one that's on there. Oh,
Mr. Hudson gonna be online or is he coming in person? I mean, mute. Is he gonna be, hold on.
Well, hello, everybody.
You got it? You need me to unmute.
Okay.
All right, you got it. All right, go ahead. Hey, Mr. Hudson.
Hey, Judge Manning, great to see you.
You
Man,
too.
I so do miss you with Orca. We need you. I'm finna file a formal complaint. Cause that thing crazy. I can't get no dates over there. We miss you, Judge.
We're on live stream.
Okay.
Okay. I don't mind a compliment online every now and then.
I just
Okay.
didn't want him to take it to another place.
I'm not.
You have the recommendation for your client?
Judge, when Mr. Morris was prosecuting, we had agreed that my client already serving a year in Georgia Department of Corrections, and so he was gonna run the year concurrent.
Let's see. Hey, Mr. Roberts Gotel, wake up. There you go. Sit up straight. How we go? All right, what do we got? So, what are we doing here?
I mean, I think I don't know what Mr. Morris, Jacoby, the recommendation, I think, is 10 years to serve.
What? No, he said 10 serve 1. That's what we was actually at. So I guess we're gonna have to roll this over to the trial calendar.
I mean, yeah, I mean, they caught him with a rifle in his hand, so he's a convicted felon.
Okay. Well,
And oh, I guess we should have had Miss Sanders out here, huh? Hold on, we'll wait on Miss Sanders. Oh, I gotta call her. Which one of these buttons? is-
Y'all want it on the record or y'all, I mean?
Yeah,
yes,
want this on
we
the-
want it on the record because we're gonna have to roll this over to the trial calendar.
Hold on.
Oh, we thought you were missing.
I just pushed the button.
They caught him with a rifle on the rest.
Hold on.
It'll be real about 5 seconds and you.
Here you go. You can actually hold on to this, Miss Sanders, so you can see it, that position.
Oh, no.
Oh, okay.
I have it on my tablet.
Oh, okay, on your fancy tablet.
Oh, she using a tablet.
Yeah.
And this is who?
Justin Roberts Gotel. And it's, okay, we're ready. We have our court reporter here. Mr. Hudson, you want to start over again?
Yes, Ms. Woods. So to set up the record, Mr. Jawar Mars was a former prosecutor. We was on 3 trial calendars, and so we was 3 calendars previously. And I thank you, Ms. Woods, for getting Mr. Roberts Gotel. Initially, we talked about a plea, and his exact plea terms was he wanted to add at least 18 months, 10 served 18 months. So I asked him, would he consider a year? He said, whatever he did, it'll be a minimum of 1 year to serve. So he initially came to me with 18 months. We never heard 10 years to serve. Hold on, Mr. Roberts. So
I just want to spend.
No, sir. Nope. Let Mr. Hudson do all the talking right now.
yes. So that's what I had conveyed to Mr. Roberts Gotel. There was no injury in this case. No one was shot, none of that. So I will ask if they could talk to Mr. Morris about this. But Mr. Roberts was under the impression that he was going to get time run concurrent to this sentence, or at the most 18 months. That runs concurrent to the 1 year that he's already will serve. Judge, I believe that was Judge Drake had revoked 1 year, revert 1 year of his probation from the 2019 case, and we was running everything concurrent.
Yeah, so he's charged under 133, which is possession of a firearm by a convicted felon during the commission of a crime, which carries a mandatory 15-year sentence to run consecutive. I'm willing to dismiss that and go forward on counts 1 through 3 with a recommendation of 10 years to serve. I think given his criminal history, given that he has 5 prior convictions, including 1 from 2021 for aggravated assault and possession of a firearm during the commission of a felony, as well as possession of a firearm by a convicted felon, which is the basis for the 133 charge. I don't think if he was offered 10 serve 1, he should have taken it at the time. I cannot in good conscience recommend that sentence given the evidence in this case of his criminal history.
Well, I was not available, so and then it was I wasn't present for court, so that's the reason why he didn't take it. So we was trying to get it back on the calendar, but I mean, we not 10 to serve. That's what it was.
I got
I
you.
mean, you could verify it with Mr. Mars.
I'll verify.
He had in Gotham, he hadn't had no contact with no victim or anything. I think the victim was actually his uncle in the case. So that's the reason, the basis for the recommendation.
Well, I understand. My concern is more so that he's in possession of at least 2 firearms on that day, including a handgun and a rifle, having been a convicted felon for a violent offense. So that's my basis. I understand what you're saying, Jacoby. I get it. If that's something you feel comfortable going non-negotiated with, I mean, we can let the judge decide. I can't recommend 10-1.
Okay, well, I think we probably should just roll it over to the trial calendar then.
I got you.
You know, because I don't want to risk him doing 5 years when he was under the impression to do 1 year to 18 months. That's what me and JJ was at.
I got you.
Because I asked JJ, can he come home? JJ said he's not coming home. That's what he told me. He was like, he's not coming home. I was unavailable. I was in Colorado for a funeral when he last had court and Ms. Woods had brought him over. And so I didn't know JJ was gonna get moved. And so now, if you're willing to do 18 months, I can take a negotiated plea. If not, then we'll have to just roll over to trial calendar. And I understand you the boss, so I know the procedure, Gotham. So you know how we are.
I know. You and I are cool. We're still cool. But I can't recommend. We can maybe have a discussion. I can't recommend that.
Okay.
What's the trial calendar, Ms. Woods?
It'll be after the new, we have a case going out on January the 14th. If you're telling me it's gonna be a trial, then what I'll do is, once I get the list together, I'll send you an email to find out your availability. And then get him transported up here.
And Gotham, are you gonna handle the case? I know you made the case, but are you gonna handle it or are you gonna have another assistant DA assigned?
I mean, I'll put someone in the courtroom. I think between now and mid-January, you can reach out to me and Caitlin.
Okay. And then that'll give you an opportunity to reach out to the victim because I don't believe the victim wanted to move forward. They know that Justin had mental health issues that needed to be addressed. And so it was a family dispute. So if we can do that, then that'll be perfect with us. But January 14th, Judge, I'm not on leave that time, so I'm prepared to go to trial that week. And Ms. Woods, we can serve as the backup if need be.
Okay.
All right.
All right.
Thank y'all.
All right, thank you.
Gotham,
Good
in
to
the meantime, I'll reach out to you and see if we can come to a different resolution.
All right. Good to see you, Mr. Hudson.
Thank y'all, Judge.
All right, thank you. All right.
That's it.
Thank you, Mr. Roberts. Go tell you're good.